Welcome, everyone. Thanks for coming to this first in a series of webinars on data centers hosted by CURE. This webinar is brought to you by CURE and by Minnesotans for Open Government. You are in luck because both of our organizations have brand new websites and they are gorgeous. So please go ahead and look at curemn.org and also mnog.org. They're both just great. All the information we're providing today is for your own use, but it is not legal advice. We cannot represent you as your attorney, and if you do need legal advice, we recommend that you find an attorney who takes clients and is able to represent you. But we will just be providing information here for your own general use, and we'll be pointing you to other sources of information so you can learn even more. And then, like I said, this is part of a series of webinars. We have this URL on the screen here about the webinar series on data centers. I will talk a little bit more about that in a subsequent slide. We are CURE Minnesota, or CURE, the artist formerly known as Clean Up the River Environment. And we are doing a series on data centers where we are going to cover many of the major policy issues we've been confronting and we've been learning about as advocates working on data centers. So this includes today transparency and specifically Minnesota's open records laws. Other topics we'll cover are energy. Energy use of data centers is perhaps one of its largest impacts and one of its largest potential impacts on you as a electricity user and a person who lives in the world. Water usage can vary greatly project by project, depending on how it's constructed and how big it is. Environmental review, another form of transparency law that I am very interested in talking about, and I'm excited we're doing another webinar on that topic specifically. And then also community benefit agreements, which is a concept that's been knocking around several industries, including the mining industry and energy development, clean energy development specifically, where communities can sort of create agreements with developers in order to make sure that they receive adequate benefits if a project is going to be built. So that's our whole series. But today you are at Data Centers and Transparency. Do not adjust your dial. It is exactly what you expected. It is a good hour-long discussion of government records and why that's super exciting and something you should care about. First of all, if you've never heard of CURE, CURE is a small rural nonprofit, and we protect and restore resilient communities and landscapes by harnessing the power of people who care about them. We originally started off as a clean water organization, and we now do a lot of work across a full range of environmental issues, with a big emphasis on energy democracy and clean energy development in collaboration with the communities that would host that type of infrastructure. So we are very much interested in communities being well informed about the projects that are happening in their communities and having a say in what's going to happen to them. And that's why the transparency of local and state government is so absolutely important to the work that we do. You had three very interesting speakers today, including me, Hudson Kingston, legal director at CURE, my colleague, Sarah Moradian, who is our government relations and policy director. And then we also have Don Gemberling, who is both an expert on the Data Practices Act, having worked at what is now called the Data Practices Office for a large portion of his 34-year career at in Minnesota state government. He has recently been awarded accolades from various open records. I didn't write down who actually gave you the award, Don, but you can tell us when your time is around. In 2023, he got an Open Records Award from a wonderful organization that noted that Don learned in his formative years serving in the Vietnam War that being honest about the way the government works is really important. And as a result, even though he has been retired for a couple of decades now, Don is a personal hero of mine and has done great work in keeping the Data Practices Act healthy after his time serving in public service. So I'm excited to let Don talk, and I should stop blabbing about him so we can get around to it. So I will talk at first on this topic. What is the Data Practices Act? Then my colleague Sarah will talk about how the Data Practices Act and data centers have intersected thus far. And then Don will drop some knowledge on us about non-disclosure agreements and other things that have been coming up in the context of data centers. So thank you for coming to our webinar. So my 101 presentation, what is the Data Practices Act? It is a Minnesota law first passed in 1974, and it is found in Chapter 13 of Minnesota state statutes. So if you go to the reviser's website and you look at Chapter 13, it is the Data Practices Law. It indicates what is government data, how you get it, what is not public data, and that is actually the bulk of the law is a very long list of things that are public and things that are not public, which, sometimes really long lists are very useful when you're doing your advocacy. Don will no doubt get to that. It applies to state and local government entities, and it does not apply to some things you might think it would. So it does not apply to the legislature, the courts, or certain townships in outstate Minnesota that have not opted into the Data Practices Act. I live in Fall Lake Township. They have opted in, so they have to answer my DPA requests, but other townships may not have done that. It doesn't apply to a federal agency. So if you think the Department of Energy has information, you should use the federal open records law. Don't use the Minnesota state open records law because that will not work. So what does it apply to? Well, it applies to all data and records, regardless of format. If the government has a record, if it has some sort of document or recording or something like that, that is within the law. Records are public unless otherwise classified in Chapter 13. So the agency or government entity must justify anything it withholds. Anything it says is non-public, and it has to cite to the exact reason or part of Chapter 13 or other law that makes it non-public. If you are the subject of data, there are different rules, which we aren't going to get into here, but there are special rules for people requesting data that the government has about themselves. What other laws intersect with the Data Practices Act? Well, pretty much all of them, right? So if the government is doing something and they're interacting with the public and they're interacting with someone who's reporting something to the government, then they are creating records. And then that is something that you can then request from the agency under the DPA. So for example, I saw on a agency website that all of these landfills had to report their ash data on a yearly basis. Well, it says that those records are required to be submitted. I know who has them. I submitted a request for all those records. And a few months later, I got way more information than I ever thought possible about landfill ash. More specifically, though, this law relates very closely to some other laws. It comes up a lot. So, for example, the open meetings law. So if you're dealing with a local government, you both can look at what they're doing under the open meetings law and whether that's legal, and you can use the Data Practices Act to get more information about how they're making decisions and whether they're complying with that other law. Under Minnesota law, all agencies have to have record retention policies. So what you're asking for is records that they have to hold on to, and whether or not they deleted the records in the meantime is part of their record retention policy, not part of the DPA, but those two things dovetail very well. And then as we're going to talk about in our environmental review webinar, I think the Minnesota Environmental Policy Act also relates well to the DPA. They're different types of transparency law, but they're both very much at their heart transparency laws. Okay, so this is a lot of text on a slide, and I'm sorry for that. But what are your rights and their responsibilities under the DPA? You have the right to inspect at reasonable times at absolutely no cost to yourself records that are held by government agencies. And reasonable times means during business hours, usually where they keep the data. So if you're talking to your city government, you might have to go to the city government and sit at their computer and look at their files through their computer. You also have the right to get copies, but there will then potentially be costs that you have to pay in order to get copies of their public records. You have the right to be informed of the meaning of public data, so they don't just like send you a bunch of random numbers and not explain what they use that data for. And you also have the right to remain totally anonymous and not say why you want anything. You can make requests to the governor of the state and not tell them who you are or why you're asking for it. That makes it a lot more complicated to actually get the records, but it is your right to do that way. So that is something that's open to you. And you have the right to know why something is withheld under what specific legal authority. At the same time, the government entities, either local or state agencies, have to maintain records in a way that is easily accessible. And in my experience, that almost always means they're held in digital format on their computer. They have to comply with requests in an appropriate and prompt manner. They have to only charge the actual and reasonable costs of producing the public records. And if you ask for data in its original format, they have to give it to you in that format. So you can't, if you ask for something in its original, if you ask for emails in their original format and instead they send you a big stack of paper or printed out emails, that's a violation of giving it to you in the correct format. And that can be very helpful with digital files, especially getting them in the format that they are actually used as. There are things in, like I said, a lot of the DPA is a list of things that are either non-public or a list of things that are public in certain circumstances. But like just some examples, personnel records. So like very specific records about someone's work history as a public employee is not necessarily public information. I believe that this classification is abused by certain parts of the state government, but we don't have time to talk about that. Ongoing investigatory records, I have requested records of violations at certain facilities, and I didn't get those records because they're still doing the investigation of the violation. They can't give me the packet of files yet. 911 recordings, trade secrets, but not proprietary information. So trade secrets is very specifically defined in Minnesota law, and applying that to secrets from a company will come up, I believe, when Don's telling us stuff. And then many other things. And that's just within the DPA itself. There's a very long list of things that could be non-public information. There are other laws, such as federal laws protecting student records or protecting medical records, that also would mean that something is not public information under the DPA. If they're using those federal laws to say something's not public, they would still have to tell you what their authority is for not giving it to you. And then, as I say in the bottom of this slide, Chapter 13, when you look at it as a PDF, is 192 pages long. So there's lots of stuff in there, both lists of things that are public and things that are not public. And it is worth going to the specific section on the type of data you're asking for if you really do want to know whether something is worth requesting or not. Okay, so like I said already, inspection of their records at their own facility is always free. They can charge you for copies up to 100 pages, and it can't be more than 25 cents per page for black and white copies. If it's going to be more than 100 pages, then they no longer can charge you a per page fee, and instead they have to charge you the lowest hourly wage of a employee who could work on getting you that data. In my experience, I have often not been presented with that type of bill. So it is up to the agency. They can produce electronic records, for example, and just send them to you and not bill you at all, because obviously billing you for their time is a cost to them in addition to doing the search for records. So often, if it's not a totally out of control request, they won't invoice you with the charge. But always keep in mind that the inspection is free. So if you are worried about cost and if you are in a hurry, it might make sense to just choose to inspect files on site if at all possible. Also important, or interestingly, when they are redacting things that are non-public, they can't charge you for the time they spent redacting them. So that's kind of fun. That's kind of a fun fact that I don't think a lot of people would know. Now, the DPA doesn't allow you to do unlimited things to your state agencies because obviously they have other things to do at work. but they are not normally required to create new data in response to a request. You can't make them create a new analysis or something like that. And they are not required to answer any questions. So like if you want to know how many times they bought a truck, then ask for every record of purchases of vehicles. You can't just ask them how many trucks did you buy this year. They don't have to answer that. But importantly, where the information is not public, they must provide you with a summary of that data in a public format. So if they're anonymizing something, they can be forced to give you data that summarizes data that they won't give you. So that's another fun fact. So many fun facts. Um, at some point, when you send in these requests, the agency is going to deny your request because they think something is non-public. So make sure if you're getting a denial, if your shot has been blocked, as I'm implying with this photo from the sports world, um, make sure you get an exact reason of why they think that they can withhold that, what part of Chapter 13 or other law that they're relying on. You can then go to Chapter 13 and then think of ways to re-ask for the information in a form that is public. So very much with like criminal records or other records, you have to ask for what is public, but you can get that information much more quickly if you intentionally ask for things that are explicitly public. Make sure that you get any denial in writing, and you should include their designated responsible authority in your communication. So that's going to be one person at the agency or local government who is the designated authority. And once you're in a dispute with them, you should include that person in your communications just to make sure that you're on the record in writing, disputing their denial of your request. And then there is something called the Minnesota Data Practices Office, which we'll talk about a little bit more, that has an entire page of advisory opinions. And these advisory opinions are interpretations of the law where there's a close call about whether something is public or non-public, or how long a request should be, how long before it's unreasonable for them to respond. These advisory opinions cover a lot of important issues. And if you contact or look at the website for the DPO, you might find an advisory opinion that already covers your topic. I certainly have found advisory opinions that already clarified what I needed to know. Or you could ask them for a new advisory opinion if it's a new matter that they haven't seen to already. The staff there is very helpful. They might point you to existing resources that could help you get through this and justify your request to the agency or local government. So one thing that's very squishy is what is the reasonable time to respond? The statute does not set an exact amount of time for the local or state agency to get back to you. In the federal world under FOIA, it's either 20 days or 30 days if the agency asks for a little more time. So that's 30 days versus the DPA, which says reasonable time. There are opinions from the Data Practices Office about what is reasonable. So something that's very large and sprawling, maybe reasonable is 6 months. But if you're asking for something that happened yesterday and it's only one record and you know it exists, maybe the reasonable time is 1 day. And I have asked for meeting materials and got them back in 1 or 2 days. And that's sort of it's a not a one size fits all standard by any means. But it is annoying to have to wait. So it's interesting to think about what is a reasonable time to wait. As I've said, you're going to want to check out the Data Practices Office webpage whenever you are hung up on an issue like this. They cover all sorts of great issues, including general information on the data practices law, like we're talking about, the open meetings law. So if you are concerned about data centers, a lot of what's going on in that world is going to be subject to the open meetings law, and decisions that are made in violation of the open meetings law are obviously going to be invalid because we have a whole law that requires them to make decisions in a particular way. And then as discussed, there's the advisory opinions that are already posted, and it's all really good information, useful information for looking back on. And then if you're not getting what you need from that objective government authority, I would then strongly recommend thinking about contacting Minnesotans for Open Government. Like I said, they have a beautiful new website, and they have this page that I have here with that's Get Help and Learn. And it has a draft request. It has recorded presentations, including one by Mary Jo Webster from the Star Tribune that I totally ripped off for my presentation materials. Just wonderful presentations. And there's also this form where you can probably contact Don directly and ask him questions. They are also not going to provide you with legal advice, but they have very useful and helpful information. So that is everything you might need to know about the Data Practices Act. Now let's talk about data centers.
Excellent. Thank you so much for that wonderful overview, Hudson. So CURE is one of the organizations that was heavily engaged in policy discussions happening at the legislature this year. And through that work, we saw a lot of lobbying happening, mostly behind the scenes on the part of data center owners, operators, developers, and then also industry groups trying to influence both legislators and state agencies to get their policy agendas through the legislature, the usual kind of thing that happens. At the same time, we were also becoming aware of the use of alternative urban area-wide reviews. AUARs is the acronym, at the local level to review things called technology parks or light industrial development that looked an awful lot like hyperscale data centers when you took a closer look. So, because of all this, we were really interested in trying to get records about the communications we knew were going on. Next slide, please, Hudson. Excellent. So I'm going to walk through how we crafted our requests and what we got in return so you can see how the DPA works in action, at least for this particular example. So the first thing we did was determine what information we wanted. So at the time that we sent these requests, we were most interested in communications happening about data center policy for the 2025 state legislative session. So we were looking specifically for communications from about January 2024 to May, which is when I submitted the request, 2025, because a lot of legislative work happens before session even starts. So that's why there's kind of that longer time period. As you can hopefully sort of see from the red box at right, we decided to cast a slightly larger net too, not just data center policy, but we also included proposed data centers and renewable or clean energy development to try and avoid missing things that were maybe related to data center discussions, but that might not show up just under the heading of data center. So the second thing we did then, or that we needed to do, was determine who was making the communications we were interested in. So again, because we wanted to know what was being said about data center policy at the legislature, our list included data center lobbyists, state agencies, local governments, and legislators. And again, as you can see on the right, we requested communications with any lobbyists, representatives, or agents of some of the big tech companies, and the Data Center Coalition, which is just an industry org. So you might be wondering, you can see these specific names, how we got that list of specific people. Uh, in Minnesota, sorry, next page, next slide, Hudson. So in Minnesota, folks who lobby are required to register as lobbyists with the Campaign Finance Board. There's whole definitions about what lobbying is, what a lobbyist is that we can get into later. But anybody can look up an individual lobbyist, or like we did in this case, look up a lobbying organization to see who is lobbying on their behalf. So this is on the Campaign Finance website. You go right to the Reports and Data tab, and then you can look up where that red arrow is, Lobbying Organizations Search Tool. So for what we did, you can go to the next slide. So we knew Google had lobbyists working on policy, but weren't totally sure who they were. So we used this tool to determine that the list included these folks and added their names to our report. So we did the same thing for Meta, Amazon, and Tract. I believe then we did subsequent Data Practices Act requests with some of the developers and did the same exact thing. I will say that this method isn't foolproof. It relies on there being a lobbyist or the organization being a lobbying organization and actually registering. So at the time of our request, for example, the Data Center Coalition wasn't a registered lobbying organization and didn't have a registered lobbyist. So I just knew from appearing at the legislature myself who some of the people were that might be speaking about this. So it's not foolproof, but this is a great kind of basic step to take. Next slide, please. This question about who is doing the communication is closely related to this third question that we asked. So, who has the information we're looking for? Although the lobbyists, state agencies, local governments, and legislators probably have all of that information, out of that list, as Hudson mentioned, only state agencies and local governments are going to be subject to a DPA request. So we have to make our request to those offices. And what we did too was include their staff, since oftentimes they're the ones handling scheduling or initial briefings or summaries of the meeting or anything, any communication that has happened. Um, and then we had to determine where that information might appear. So what kinds of communication are we looking for? Obviously, one of the most common ones is going to be emails, but also texts, meeting notes, calendar meetings to kind of get an idea of who maybe was at a meeting. We can't know for sure unless there's a report about who was at the meeting. And then again, staff generated briefings or memos, and also summaries of meetings. So as you can see in that very dense block of text at the right, we were asking for all of these kinds of communications from key offices at the city of North Mankato. If you happen to be on an MCEA webinar earlier today, you heard a little bit more about North Mankato. But our request asked for communications from the mayor, city council, city clerk, can also include things, certain boards that counties or cities have, or certain divisions, and then again, the staff from their offices. So what you're probably most excited to hear about now is how did our DPA request go? Next slide. In several instances, we got responses saying that there were no records. So here are some emails I got from Pine Island and Hampton, cities in Minnesota, saying we don't have any records that match what you're looking for. Sorry. But then in a few other instances, you can go to the next slide, we did get some really useful information. So North Mankato gave us over 200 pages of communications between their city staff and several developers and lobbyists. So this is just one lobbyist speaking to some folks at the city, explaining kind of what was happening at the legislature. There was an amendment that was proposed about NDAs and data centers, and this lobbyist was explaining that it was defeated on the floor, and just kind of what happened there. Next slide. Here's another, oh, this is very small. Sorry about that. So in this one, it's somebody from the city speaking to the same data center lobbyist, explaining what they wanted to do kind of in current legislation. So there's uh, a law that's in the books already that restricts the amount of water that can be withdrawn from the local Mount Simon Hinckley Aquifer down near North Mankato. So this email is just explaining that they would like to try and change that because there are data center developers approaching them who might need more water than North Mankato can currently withdraw. Next slide. We also got, oh, this is relevant to our discussion, obviously, today. I jumped ahead of myself, sorry. So here's just a first page of an NDA that the city signed with a developer, Abedin, back in 2023. So Don will tell us a little more about how NDAs kind of factor in here, but just thought this was an interesting thing to show as well. All right, next slide. We also got some text messages from our DPA request to the Public Utilities Commission. So these are between some Google lobbyists and the Deputy Executive Secretary, discussing just kind of a voice message that was left, and then subsequently planning to meet with one or two commissioners about legislative policy items. So we had asked about a voice message, but that had been deleted. So next slide. As I mentioned, not all of our requests were successful. So I want to go through a really great comparison of requests that both CURE and MCEA did to Hermantown, the city of Hermantown. So as with our other requests, CURE's DPA request focused on communications with lobbyists about data center policy. MCEA, on the other hand, asked for all records related to proposed data center development in Hermantown between the city and Minnesota Power, Mortenson, which is another developer type group, and Senator Grant Hochschild. Next slide. So what we got is there's no records to see here, notice from Hermantown, similar to what we got from other cities. Next slide. But MCA got a lot of records. So here's just two examples. There's the full list of documents that can be found at the link here. We can throw it in the chat too. The one on the left is the city administrator describing a discussion he had with the mayor about the potential project up in Hermantown. And then the one on the top right is about scheduling a meeting with the developers, the end user called Project Balloon Team, and then city staff at Elite headquarters back in October 2024. So this was a lot of information, and I'm hoping that it gives you kind of a good idea of how DPAs can be written, um, and then how, when they're written well, they can really be useful tools to get government data. That is it for me. If you want to go to the next slide.
And I do. I absolutely do. Okay, so as foreshadowed thoroughly, we are now going to Don Gemberling, who knows a lot about this topic. Don, I'm going to ask you, I'm just going to get you going on what about the NDAs, Don? Isn't it the case that government data is public by default? How do NDAs fit into this whole ball of wax?
When the legislature established the basic policy, which those of us doing this stuff call the presumption that all government data are public, they added the following language: unless there's a statute or federal law that makes the data not public. Okay. And so the emphasis there is on statute. And that's why, as you described, Hudson, the Data Practices Act is 192 pages long, because most of that is decisions by the legislature to make certain data not public. However, a contract between we'll pick on a city, between a city and a developer to not disclose, I love the language, confidential and inside information, is not effective if someone makes a data request for the data about those negotiations. Because an NDA, a non-disclosure agreement, is not a statute, okay? And actually, this has come up in the past on a number of occasions. And for years, we've been saying the same thing, okay? If in the agreements I've seen, and thanks, Sarah, for the other one, the, the agreements are almost always written by the company or by the potential developer or the person working with the city, a legal person, and they often don't say a word about the Data Practices Act. Okay. I saw one, and actually Minneapolis is working on one on a separate issue that says they'll sign a non-disclosure agreement if it doesn't prevent the disclosure of information that's public under the Data Practices Act. So the bottom line is NDAs, if somebody makes a request for data, as Sarah has demonstrated the ways you can do that, they can't cite the NDA as a reason for not disclosing the data because an NDA is not a statute, okay? And essentially that's the only basis under the Data Practices Act in which you can deny public access, okay? Now, if they say a given NDA includes proprietary information, then we have an issue under the Data Practices Act, which Hudson, you talked about, which is the Data Practices Act, unlike the Federal Freedom of Information Act, does not protect proprietary information. It only protects trade secrets. And the language in the Data Practices Act that deals with that is based on the Uniform Trade Secrets Act. I hope I'm not boring people, but that has a very limited definition of trade secret. What it says is a trade secret is something like the formula for Coke or the algorithms that drive how Google does what Google does. Proprietary information tends to be, our client list is blah, blah, we're making X amount of money off of so-and-so. That's proprietary information, but it's not covered by the trade secret provision of the Data Practices Act. So as far as some of us are concerned, all of that information is still public, okay? And that goes to your point about, and this is a really important part. If you ask for data and a government agency says, well, you can't have it, you really have to make sure, and you have to make the request. They don't have to tell you unless you make the request, that you're saying, okay, what provision of Minnesota statutes or federal law makes that data not public? Okay. And that does two things for you. Number one, it gives you a chance to check on whether or not what they're telling you is correct. Okay. And number two, it also gives you the chance to figure out whether or not, if indeed the statute covers the data that they're talking about, what it says at a detail level. Because deep, and I hate to go here, but I have to, deep in the detail of the Data Privacy Act there are sometimes things that say the following data about individuals are private. But if you have a record that's a mixture of private data about individuals and data about companies, only the data in that record that's about individuals is private, not the data about the companies. That, it really is at the, I'm trying to think of the right word, the really detailed level of how the Data Privacy Act works. So as far as I'm concerned, NDAs are public information, like
And
any other contract.
Don, if someone was trying to get something that was incorrectly designated as trade secret, would they go to the data practices office first? Is that the first place you would check to see if that's
Yeah, no,
true?
yeah, I can't. I can't. Well, you didn't mention there are like 600 opinions. Okay,
Yes. So
they do
read
have.
all of the 600
Yeah,
opinions.
yeah, they do have a keyword search capability. Okay, and I was there when we first got the opinion authority, so I either wrote or edited the first 500 opinions. Okay, so and I can't give you an exact number, but there were X number of opinions about trade secret, which essentially said the same thing I said a few minutes ago. And that's a place to go. Number one, you look at the opinions, and if they agree with you, then go back to the agency, this whatever agency you're dealing with, and say, hey, look, there's a commissioner opinion here that says when you're telling us an NDA says we can't disclose information about who the potential client is, that's not a trade secret, and therefore it's public. And if you don't get anywhere with that, then you can go back to the DPO office and see if they'll give you an opinion on that issue.
Yeah.
So,
Yeah, and if you think you have an advisory opinion, you should show it to the government entity because once they're on notice of that opinion, then they're responsible for it. So they're not supposed to necessarily have Don's the only one who's memorized all the advisory opinions. Most agencies don't know about all of them. But once you bring it to them, then they become accountable for knowing what's in it and following it. So it's always good to keep in communication with folks while you're working through the request. I'm gonna lob one of our questions at you, Don. I don't know if you'll know the answer to this. If a presidential executive order on artificial intelligence came along and it said bizarrely that we're preempting all state laws and we're making, anything related to a data center super secret, would a presidential executive order be relevant here or would it just be totally irrelevant to the DPA?
I think it's irrelevant, but the problem these days, Hudson, as we all are kind of learning,
Yeah.
uh, the Trump administration does all kinds of stuff that's many of us think is illegal, and what it really is an invitation to sue them. Okay, and that's an unfortunate reality, but it is what it is. I just don't think an executive order is not a statute. Okay. So,
Yeah.
yeah, now, if Congress passes a law that says that, then an age, it'd be really interesting to see if somebody would rely on that and deny access to data in Minnesota. So,
Yeah.
yeah. So,
I'm I'm worried about a lot of things right now, but I'm not worried about Congress passing a bunch of laws. That's one thing I don't worry about. It doesn't keep me up at night.
I,
Um,
before you go any further, Kingston, I need to
yeah.
repair. I need to fix something. You said I learned a lot about this in the Vietnam War. I was a draftee who served in Germany. I wasn't in Vietnam.
Okay.
It's one of the
Okay.
things I feel strongly about. I got lucky. Now I sat on the border of Czechoslovakia and East Germany, waiting for those evil communists to come and get us, but they never did while I was there. So,
Okay. I didn't want to pump you up too much, but I do think that there was some government transparency issues around that war, and it may have left a lasting
oh,
impression on
it
you.
it played a major role in the current focus on government transparent, what we call government transparency. Oh no,
Yeah.
absolutely. Yeah.
Yeah. Do you know off the top of your head? I know that other states do have laws like the DPA. Surprisingly, Florida has one of the strongest ones. I've had a Florida government employee send me a hard drive out of his computer. He just pulled it out of his computer and mailed it to me.
Mhm.
Um, the question that we have is North Carolina and MS, which I believe is Mississippi. Do you know if they have strong open records laws?
Off the top, well, number one, I'm not sure. Okay, I'm going to guess the usual pattern across the country has been to adopt something like the Federal Freedom of Information Act. Okay, Florida, with which I have quite a bit of familiarity, they took a different track maybe 30 years ago. They passed a constitutional amendment in Florida about public access. And they included in that constitutional amendment public access to all branches of government in Florida. Okay. So, and so for a while they kind of stood out. They were an outlier. They just kind of stood above a lot of people. But frankly, in our Data Practices Act, if you looked at the policy decisions at a detailed level, a lot of what we have is very similar because at some point then Florida to implement their constitutional amendment adopted a Freedom of Information Act approach. Okay. The best example of that is always under the Freedom of Information Act, you can't get trade secret and proprietary information. Okay. It's
Mhm.
one of the exemptions. So
Yeah. Um, here's one again for Don. What is it? Wait. What should you do if the government you send a data request to wants to charge you money for that request? Do you have any options if you're getting back a bill for your request?
if you ask to inspect, which is one of the clearest parts of the Data Privacy Act, you cannot be charged for the ability to inspect government data. Okay. And so the response to that is to say, well, I'll be more kind than I thought about being. The response to that is, look, look at the statute. You can't charge me for inspection. Now, if your request goes to copies, then you had a slide about that. What the whole thing about the 100 pages or less or reasonable costs, all that kind of thing. That is indeed part of the Data Practices Act. But what we've always tried to tell people is to the extent you can, and we realize the practical difficulty, always act to inspect, ask to inspect, okay?
Yeah.
Because what inspect gives you is the ability, if you actually get to inspect the data, you get the ability to say, oh, now I know what I really want at the detailed level. Okay.
Yeah.
So inspection's getting more difficult, frankly, because of technology. One would think that it ought to be easier, but the software packages the governments are buying they're buying off-shelf software to provide public access. They're all oriented toward uh, federal-like freedom of information statutes, and they just don't fit here. Okay, among other things, they don't take into account. They kind of assume that everybody asks for copies. Well, no, 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 no. What we've been pushing and what's been in the statute, frankly, since 1979 is free inspection. And
Yeah.
that's one of the places where, for lack of a better word, in the contest between the government and the citizens, that's one of the things that's on the citizen side of the scale because it's really powerful. Because, as you mentioned earlier, if they have to do some separation of public from not public data, they can't charge for that. So sometimes what it'll lead to, and this is an important thing to understand, it may lead you to a negotiation, and that's fine. I mean, if people negotiate and the citizen request is accomplishes what you're trying to do, who cares? Okay, it's just it's a way to do business, for lack of a better word. So.
Yeah. Yeah, and I'll echo what you said. I often, when I do a request, I check both boxes that I will inspect the records and receive copies. And I say, if you want me to come inspect, I'm happy to do that. Or you could send me all the copies. And and in this day and age, they usually just send me the copies. But I did have a very nice day at DNR one day, sitting at their computer and getting exactly 99 pages of printouts. And it was worth it. I got to talk to people who worked at the agency. I got a little insight on their lives. They're people, they're doing
Oh,
the
yeah.
best they can. Um, so you don't be afraid of inspecting. It makes us human. Inspecting records makes us human. Um, okay, I'm gonna collapse two questions. And again, probably send them to Don. Uh, First question, Don, what is a fair amount of time to give local governments to respond? How often do you check in with them? And I guess I'll just say check in often. And then second, with entities such as local governments who may be smaller in size and not familiar with the data request law, how do you make sure they are complying with it? I think those two are somewhat intimately related.
Um, One of the things that I get cranky about is we have had this law in mostly its current form since 1979. Okay. And so even with small governments, when they say they really don't know what they're supposed to do, well, come on. You know, you have the League of Minnesota Cities, you have the School Boards Association, you have all these government associations that are there to help you understand. One of the things I really liked when I was working for the state was going out and training. Okay. And I trained I trained the city of Minneapolis. Frankly, I don't think I ever trained Funkley, which is Minnesota's smallest city, but I trained cities of a comparable size. And so for them to take the position, well, we really don't know what to do. Well, among other things, they can call the DPO office and find out what to do. So a certain amount of patience is good, but you also need to kind of equip yourself with what their level of understanding is. Because if you have a better understanding than they do, then you're in a better negotiating place. For example, even small cities, we'll pick on cities, are required to have either on a city bulletin board in the city hall or on their website, if they have one, the policies and procedures that are required by the Data Privacy Act, under which the public can look and see, okay, in the city of Funkley, who do I have to go to get access to data? And other things like time and costs and those kind of things. And again, those have been requirements since 1979. When I was at the DPO office, one of the projects we did after talking to the legislature is we produced model policies and procedures on how to comply, okay, and made them widely available. And to some extent, because there are parts of the Data Privacy Act that haven't really changed since 1979. Those models are still, they're still okay. Okay, they're still you can follow them. So I think I covered both those. I hope I
Yeah.
did.
Yeah, I think you did well. I mean, I've found that like even counties that appear to be hostile to this have really good policies on their websites too. They post pretty good policies. They designate who their responsible official is. They may only give you their fax number, but they still post pretty good policies, which I'm happy about the state of play there. Sarah, couple of quick ones for you. Are rural electric cooperatives and or their elected board members subject to the DPA?
They
Excellent.
are not.
Yeah, they are not government entities.
Yeah, so DPA is just as Hudson said, just for government entities. So, like I was mentioning in my search earlier, it would have been great if I could do that. But no, it's just the state agencies, any government entity. But Don has something.
Um, I'm going to struggle for detail, but there are some cooperative arrangements on power among government entities. Okay. And those cooperative arrangements are subject to the Data Practices Act. And how do I know that? For years, they've been going to the legislature and trying to get out from being subject to the Data Practices Act. I wish I could come up with a specific one, but there's one in southeastern Minnesota that's
Yeah, I was going to say, Sarah, do you remember the name of the joint governmental board that does
yeah,
energy development in southeastern Minnesota?
Not
yeah,
off the top of my head, but yeah, this is why we
They're
have Don
cool.
here. He
They're
knows all the
cool.
details.
What
yeah.
they
No,
do
the
is very cool, but they are governmental, so they would be subject to it. Yeah.
yeah, and what I think of sometimes is the obscure parts of the Data Practices Act. There are provisions that deal with what the Act calls statewide systems, and essentially those are things like joint powers agreements, or entities that are in existence because of joint powers agreements. And they're subject to the Data Practices Act. And actually, if you dig into some of the detail, you'll find some reference to the one similar to the one in southeast Minnesota, the name of which I just can't pull out at this point.
Yeah. But I will verify they do exist because I
Oh,
remember, yes, I also don't know what they're called. Sarah, I'm shooting fast because we got really good questions and we might get through all of them. If someone isn't sure if their town is working with a tech company but want to find out in the early stages, what data requests would you suggest they make, just in general?
That's a good question. So when we did our data requests to cities, it's a little different because a little different in the sense that I was trying to figure out what cities might even have been approached. So what I did, I was looking for some of those cities with that had had that AUAR, that alternative urban area-wide review. So if a city has that at that point, you can still get records and stuff, but that's further along in the process than I think what this question is asking for. I think generally, the keywords that you're looking for. Or if you're interested in a data center, technology park is often something that comes up. Um, a light industrial, all of those kinds of words. And then again, like look to the city, as we were just talking about, look to the city's kind of who you're supposed to send the request to. Is there a specific form they want you to use, or usually you can turn in your own letter. You don't have to use their form too, but that will kind of save you time and aggravation. If you're not totally sure, you can at least kind of narrow down if you can get a good timeline of when you think maybe, how many months, years you want to look at, certain keywords that you think are related to data centers. Data center is probably a good one. Um, and then just making everything else as easy as possible. So you're not getting a response that says, oh, we don't know. Um, and then
Yeah.
follow up like Hudson suggested.
Yeah, picking names of companies, names
Yes.
of lobbyists, proper nouns help a lot
Yep.
if you have a feel for those. I mean, Mortensen is a
Yes.
construction company and they're the ones who hold all the secrets in Hermantown. So like focusing on Mortensen as opposed to the lobbyists was what MCEA got
Yes.
all their records using. So it is easier, like, say a developer is buying up a bunch of land in a block in your community, you can find their name. That's a name that is knowable, and then you would do the Data Practices Act based on the information you do know in order to find more information that you don't know.
And if you're willing to, in some cases, absorb a lot of data, you can make very general requests. Government entities tend to hate them, but you can make them. Okay. So, for example, you go to the city and you say, I want to inspect all data documenting any and all development activities the city is engaged in. Okay. That's a valid request under the Data Practices Act. They won't like it, but and you may get lots of data depending upon the size of the city, but it is a valid request. So part of the art of this is really formulating the content of the request. Sarah's, I every time I see the stuff that you use to uh, use with the lobbyist identification, I just go, oh yeah, God, that's great. Then I look at the list of lobbyists and I say, oh God, it's the usual list of suspects. So yeah, no. Anyway,
Okay, so we got a couple questions about energy use, and I would like to answer them, but I'd also like you to give your thoughts, both of you. Is amount of energy used a trade secret? And then more specifically, we've run into a broad use of trade secret. Is the amount of energy a proposed data center will require a trade secret? So I think the question is about the entire facility as opposed to like how much each and every chip, if
yeah.
that helps you answer the question. Because I think each and every chip might be a trade secret, but the whole building, is that a trade secret?
No, given how Minnesota defines trade secret, I can't see that to be a trade secret. I can see it. And frankly, I've encountered that argument prior, frankly, before data centers. And this is kind of a backwards way to support my point. Companies have come to the legislature and asked to have that kind of information protected from public disclosure. And if I remember correctly, and I need to emphasize, I think I'm right, the legislature's never been willing to accept that. Okay. And I would hope that, particularly given what's going on with the data centers, that they would really not want to accept that kind of classification of data for energy usage. There's a utilities section in the Data Practices Act which deals with municipalities who have their own utilities. And I think in that section, the amount of power you use in your house, if you got a publicly owned utility, is not public. But that's not what we're talking about. So
Yeah, no, we're talking about facilities that use the entire electricity of a large city. So I think it's pretty easy to see a difference between those types of facilities. And in our experience, the entire amount of electricity that a facility will use is usually something they're willing to tell you. Because they're talking about building like four buildings, right? And they won't necessarily tell you what each server is going to use electricity wide. That might be actually something they make money off of. But the entire building is too general for them to call that a trade secret. I don't think it's possible for them to say, oh, you can never know how much electricity this facility is going to use.
yeah, when
Um,
I try and keep it simple, is it's the same thing as the formula for Coca-Cola. And it's
yeah,
not, just not.
yeah.
I will say, I know we're getting really close to time, but just to Don's point about the legislature usually not wanting to add things to not being non-public. Unfortunately, this year in the data center laws that were passed, they did have two things that were added. One was a pre-application review for DNR for water appropriations, and that information, the pre-application information, is classified now as non-public data until, of course, they submit an application. A data center submits an application, and then the second one is related to this exemption that you don't have to pay into Energy Conservation Optimization Act. Instead, a data center can pay into kind of a weatherization fund. And that information about the amount of energy they use there and which tier they fit into is classified as non-public data. So it's interesting to see kind of what your experience was, Don, and what maybe is shifting this, as we get further
Yeah,
along.
Yeah.
Sarah, that actually causes me to ask a question. Were there actual public hearings on those two things, or did they sneak them into the omnibus bills?
I'd have to check for you, Don.
Okay, yeah, increasingly we're seeing stuff that's never had a hearing suddenly appear in an omnibus bill, and we don't see it until, after the session is over because nobody sees the omnibus bills except staff until after the session is over. So,
Yeah. Yeah, and that's a good reminder to all of us that we need to protect the Data Practices Act as strongly as we can every legislative session so that we can keep what we have.
yeah, tomorrow
Um,
is the Legislative Commission on Data Practices Act is meeting, or
right,
data
very
practices and data privacy. And I haven't seen it yet, but a friend of mine gave me a summary of what the city's testimony is going to be, and you should all read it. So it's posted on the commission website.
I think we have time for one more question, maybe slightly, maybe just one. Um, so I think this is the difference between what the DPA requires and the negotiations that Don is talking about. How do you ask for an explanation of voluminous data, technical data provided? What type and amount of government explanation should we advocate for? What do you think, Don?
What the statute actually says is not, frankly, it's not explanation. It says you can ask the government and they're required to tell you the meaning of the data. Okay. And historically, what that came from is government's overuse of acronyms and other obscure language. So that if you got the data and you essentially couldn't decipher it, then you go back and say, explain to me what I'll use a dumb example, what an EQB review is, because not everybody knows what that means. Okay. And the thing you mentioned earlier about the environmental, the additional transparency, some people may not understand the terms that are used there. Okay. So, yeah, that's that's really what the explanation part is about. In some ways you get more if you don't try and enter into that kind of dialogue with them, but you ask them what statute makes this data not public. Then you may
Mhm.
have to go to other people more learned than you and whatever the topic is to get a clearer explanation of what the heck they're talking about. Okay.
Yeah.
Yeah.
And I would also add that when a government employee is trying to get out of your request, they're willing to negotiate a lot of things, and they might explain what the records look like on their side in order to try to get you to reduce the things you're asking for. So that's not
Absolutely.
in the DPA, but that's part of the talking to them process.
Yeah, before we sign off, you can go to the Mnog website, fill out our form to get questions answered, but you can just call me. Okay, uh, I'm one of those people that doesn't mind phone calls, and I used to say, well, my number is even in the phone book, but people don't know what phone books are anymore. So
People
anyway,
can't buy phone books anymore. That's true.
651-699-6553. And I have an ancient recorder. So, but it records, but I also don't use caller ID. So you gotta leave your phone number. So, okay.
Yeah. Well, that's extremely helpful of you, Don. I feel like we can't end better than that. Thank you so much for joining us and
You're welcome.
answering almost all of the questions. We have a couple more, which hopefully will save them and be able to shoot a few people some emails. I appreciate everyone coming and learning about one of Minnesota's best laws and the law that keeps us honest as a society. Thank you for being here for this. And yeah, as Don said, um, please go to the mnog.org website, and his personal contact information is on their webpage. And then also, we will be doing additional webinars in this series. I'm really excited. We do have some more questions about rural electric co-ops. You're going to want to come to our community benefit agreements webinar, the last one. We can talk about co-ops the whole time, you guys. So please go to our website. We will add more information about the webinar series as we fill in the details. And yeah, the next one's on energy. So lots to talk about electrical usage, lots to talk about backup generation. Will the backup generation be really, really dirty or really, really clean? You'll have to come to our next webinar to find out.